everyone. In the last class, we have discussed about the some important topic of the contract under which we have discussed under section 59, and in that we have discussed about the application of the payment of the debt in the contract act. So when there is a debt upon the debt by one party up to the another party, then how the debt of the contract is recovered. For example, if I am having a debt of 5 lakh rupees upon you, then if, for example, I'm having 3 to 4 significant debts together altogether, then how the debt can be recovered. For example, if I am having 3 debts up from you, then if I am paying you 3 lakh of the rupees, then it is my discretion if I am specifying that which specific debt I want to recover. That depends upon my discretion to decide. Okay. That is what we have already discussed under section 59, that what kind of the application of the payment of the debt, when and how the debt is being discharged. And then we have discussed under section 62, that the of the novation, rescission and alternation of the contract, under which we have discussed that when there is the different kinds of the contract. For example, there is a contract between you and me that I am going to make a artwork for you, that I have taken advance amount of 3,000 rupees from you, and in return I have promised that I will make a artwork for you. Okay, but there is a little negotiation and alternation in our promise, that instead of me, my brother or my sister is going to the performance for you. And you are also agreeing upon the same topic, that yes, even if I am not doing the performance of the contract, if my sister is doing the same performance, you are okay to accept the performance. So, in that specific circumstances, if you are once agreeing for those specific kind of the performance of the contract, then in that circumstances, yes, the original contract need not to be performed, and the newly initiated contract comes into the force. For example, when the there is the alternation in the contract, that instead of me, my brother or my sister is going to do the performance of you, and you are agreeing upon that, you are saying okay to that particular contract, then in that specific case you cannot sue me for the non-performance of the contract. You cannot tell me that, ma'am, why didn't you perform the contract? Why didn't you make the artwork for me, and you are liable for that? No, you cannot do that, because there is the alternation of the performance of the contract. The alternation is, instead of me, there is another person who is who is going to do the performance, and you have accepted that another person for the specific performance of the contract. That is why the contract is being altered and the alternation of the contract is totally accepted. Got it? So, then the next point, we have also discussed that the promise may dispense with a remit performance of the promise. And under that, we have discussed that every promisee may dispense with a remit, wholly or in part, the performance of the promise made to him, or may extend the time for such performance, or may accept instead of it any satisfaction which he thinks fit. Just let's have a discuss upon the illustration of this. A promises to paint a picture of B, afterwards forbids him to do so. A is no longer bound to perform the promise. Okay. So, under section 63, we have discussed when there is a person who is the promiser. Promiser is ready to do the performance from to the promisee. Okay. The promiser, when he is ready to do the performance, at the meantime, the promisee is forbidding the promiser or prohibiting the promiser from doing the performance. For example, there is the agreement between you and me that I am going to teach you the whole Indian Contract Act with the amount of 10,000 rupees of the fees. So there is the agreement between you and me that you will give me 10,000 of the rupees, and in return, I am going to teach you the whole contract act altogether. Okay. So when there is the mutual agreement between you and me that I am going to teach you the contract act and you are going to pay me 10,000 of the rupees, I am, as the promiser, I am ready to do my performance. I am ready to teach you the whole act. And when I am going to do my performance, before my performance, you are prohibiting me that no, ma'am, I don't want to learn contract from you and I am not going to pay you 10,000 rupees. So when you are prohibiting me from doing the performance, or when you are prohibiting me from doing my part of the performance in the contract, then in that case, I am not bound to do my performance altogether. That is what we have discussed under section 63. Uh, and we can take another example of this. Actually, it totally depends upon the promisee, that how the promisee is being satisfied with the performance of the contract. For example, I have taught you the half portion of the contract act. Okay, I have taught you the half portion of the contract act, and then you are prohibiting me that, ma'am, I am having some certain kind of the works or I am traveling somewhere, so you don't need to teach me the whole contract act altogether. Then we can just terminate the contract over here. Okay, but in return you have already paid me the 10,000 of the rupees. I told you that yes, see, you have already paid me the amount of the 10,000 of the rupees in advance. And now you are telling that half of the portion of the contract act is completed and now you want to terminate the contract over that. And as per the contract, I am not responsible, or I am not liable to pay you back the rest of the amount of the fee. Okay. Because you have already done the payment to me and I am ready to do my part of the performance. So as per the contract, I am not going to pay you back that 10,000 of the rupees, but I am ready to teach you the whole act itself. But you are telling me that, ma'am, I have learned the half portion of the contract and now I want to stop it here and now I want to close the contract over here. Then in that circumstances, if even if the contract was prior that, you are going to pay me the whole of the 10,000 rupees in return of the whole act. But now I am getting that 10,000 rupees in return of the half teaching or in return of the half completion of the course. Still, the contract is effective and the contract is a valid contract because it is the choice of the promisee for the performance of the contract. The promisee has chosen himself that yes, this is the term, this is the condition I am accepting. Got it? So we can take another example of this. That, for example, you have taken a amount of debt of 5,000 rupees from me. Okay. So I have paid you and you have to pay me back that 5,000 amount of the rupees. So when there is the payment, the debt, there is the time comes when the debt is to be discharged. 1 second. Yeah. So I am the debtor over here, the person who owes the money. Okay. So as the debtor, I have paid you the amount of the 5,000 rupees to you, and you are the person who has taken the specific amount from me. Before the repayment of the specific amount, you are coming to me, you are requesting me that, ma'am, I don't have that much sufficient amount or sufficient source of money to repay you. So I request you that instead of 5,000 of the rupees, can you please close the contract with the amount of 3,000? Please excuse me for the amount of 2,000 of the rupees. Okay. So I agree with your situation, with your circumstances. I agree that yes, actually, this person is actually suffering. This person is actually in problem. So what I did, I said, okay, I agree on this. So You paid me 3,000 of the rupees and then the contract is closed. Afterwards, if I am suing you or I am filing a suit against you that see, this person has taken the 5,000 amount from me and now this person is paying me back only 3,000 and the rest 2,000 he is responsible to pay. In that circumstances, you are not liable to pay me the rest amount of the 2,000 of the rupees because I only agreed with you to sort out the contract or to close the contract with you with the amount of 3,000. I only agreed with you when you said that you are incapable to pay me that 5,000 of the rupees and you requested me to close the contract with the rupees of the 3,000. I agreed with you to take 3,000 instead of 5,000 and to accept the contract. So just because I have previously accepted the contract, I cannot deny it later on. I cannot sue you for that specific circumstances again. So here you are not responsible to pay that 2,000 left amount. Got it? So this is about section 63 we have discussed. The next point, consequences of the rescission of the voidable contract. Okay. And we have discussed that when there is the rescission or denial in the voidable contract, the person who has got the benefit from the contract is liable to return the specific benefit to as far as maybe from the person he or she has been received it. That means if you have received any kind of the benefit from any specific person on behalf of a specific contract, then in a specific circumstances you have to return or you have to pay back or any kind of the benefit you have received from the voidable contract, you have to give it back from whom you have received that specific benefit. Okay, so next section 65 we have received about the void agreement or the contract when it becomes void. And we have discussed that when there is the presence of the void agreement or the void or when a contract becomes void later on, the party who has received the specific amount of the benefit from the another party is responsible or liable to compensate it or to restore the benefit from the person he has received that benefit. For example, uh, let's see, let's take an example that there is an agreement between you and me upon the selling and buying of a specific kinds of the drugs which is prohibited in India. Okay. So we both know that that specific kind of the drug is prohibited in India, and we know that the selling and the buying of the drug is totally illegal in India. We have the idea on that, but even if after the knowledge that the kind of the drug is totally prohibited and it is void in nature, we both are entering into the contract. We both are agreeing that yes, okay, we are going to continue the contract further. Okay. So what is happening that the selling and the buying of the drug is continuing between you and me. Okay. But afterwards, there is the dispute between you and me and the contract is terminated. Okay. So when there is the termination of the contract, before the termination, we have done the deal or done the business of, for example, we have done the business of 50,000 of the rupees and you have incurred the benefit of 50,000 rupees from me. I have delivered you the instrument of 50,000 of the rupees, the drugs of the 50,000 of the rupees, and you have utilized that drug. You have taken that drug or you have used it at some other places. Okay. So you have taken the benefit of 50,000 rupees from the me from the specific void agreement. Okay. even if the agreement is void ab initio, even if there is no legal implicability of the agreement, even if we know this agreement is not will not be called a contract, this can be called only as agreement. This is not a contract, this is an agreement only, and that too this is called a void agreement, not a valid agreement. And the void agreement cannot be a contract. An agreement which is enforceable by the court of law is the contract. And as because this agreement is having the void nature, or this agreement is not legally implicable, not legally enforceable, this is called a void agreement. And just because this is a void agreement, the contract which is arised from this agreement is also called a void contract. Got it? So here, even if this agreement is void and you have received the benefit of 50,000 of the rupees from me, I have performed my part of the performance, but you have not paid me back that 50,000 of the rupees. So here you have to restore that specific benefit to me. You are liable to pay me that 50,000 of the rupees to me. In another circumstances, we have entered into the agreement to selling and buying of a specific drugs which was not prohibited in India, which is legally valid in India. But after entering into the contract, after some days of the business, the drug is prohibited in India. Okay. So when the drug is prohibited, the contract was before, it was a valid contract because there was the legal implicability of the contract, and in fact the selling and the buying of the drug was legally allowed in India. It was happening with a proper procedure. But afterwards, the drug became prohibited in India. So when the drug became prohibited, then the contract became void. The contract was a valid contract paper because it was having a legal implicability. But when the drug is prohibited in India, the contract became void. Okay. So here the valid contract has been converted to a void contract. Yes, clear? So when the valid contract has been converted to a void contract, in this contract you have occurred the benefit of 2 lakh of the rupees from me. Okay. And when the contract became void, are you responsible to pay me back or to restore that benefit of the 2 lakh to me? The answer is yes. You have to restore the specific benefit of 2 lakh to me. When the contract was in force, when the contract was valid in nature, you have occurred that specific benefit of the 2 lakh from me. And when the contract became void, or due to its legal inimplicability, still I am capable to restore my part of the benefit from you which you have got due to my performance of the contract. Okay. So this is what we have discussed under section 65. Then comes section 66. Then we have discussed section 66. Yeah. Then we have discussed section 66, which speaks about the mode of communicating or revocating the rescission of the voidable contract. Okay. What does this section speaks about? The rescission of a voidable contract may be communicated or revoked in the same manner and subject to the same rules as applied to the communication or revocation of the proposal. So when there is the communication or revoking rescission of a voidable contract, it will be done as per the same procedure according to the communication or revocation of the proposal. That means the mode of the communicating or revoking the rescission of the voidable contract. Okay, we have discussed under section 3, 4, 5 the communication and the revocation of the proposal. Like we have discussed when the communication of the proposal is been completed, when it is coming to the knowledge of the another party. That means I am communicating a proposal to you. When the proposal is received by you, when you are getting aware about the proposal, then in that circumstances, the proposal is being completed. Okay, the communication of the proposal is complete when it gets it gains the knowledge of the another party. And the revocation of the proposal, we have understood that when there is the revocation of the proposal, the revocation of the proposal is completed when it is informed to the party, to the another party, before the receive before the communication of the acceptance. For example, uh, you have proposed me about something, okay, and I have accepted that proposal, okay. Before I accept the proposal, or before I inform you about my acceptance, your revocation must reach to me. That means अगर आप और मेरे बीच में किसी भी तरह का प्रपोजल हुआ है, यू हैव प्रपोज्ड मी समथिंग, ओके, उसी के बाद यू हैव गिवन मी द 2 days ऑफ द टाइम पीरियड कि 2 दिन के अंदर आप मुझे सोच समझ के बताइए. 2 दिन के बाद मैं सोच समझ के आपको हाँ बोलने वाली हूँ दैट यस आई एम एक्सेप्टिंग योर प्रपोजल. बट बिफोर माई एक्सेप्टेंस यू मस्ट हैव टू रिवोक द प्रपोजल. अगर आपको प्रपोजल रिवोक करना है तो आपको पहले ही रिवोक कर देना चाहिए बिफोर माई एक्सेप्टेंस ऑफ द प्रपोजल. दिस इज व्हाट वी हैव डिस्कस्ड अंडर सेक्शन 3, 4, 5, revocation and communication and revocation of the proposal. Okay. So when we're talking about the rescission of a voidable contract, the may be communicated or revoked. Okay. It will be done in the same manner as per the communication or revocation of the proposal. Okay. Then comes section 67. It speaks about the effect of neglect of the promisee to afford promisor reasonable facilities for performance. What does it speak? If any promisee neglects or refuses to afford the promisor reasonable facilities for the performance of his promise, the promisor is excused by such neglect or refusal as to non-performance caused thereby. Okay. So we can just understand it through an illustration. Okay. For example, I am the person who does the repairing work in your house. Okay. So you have appointed me that ma'am, uh, I want you to do the repairing work of my home. So I said, okay. There are my staffs who went to your home. Okay. They asked you that, sir, ma'am has sent us that you wanted to repair your home. So can you show us that what portions of your home is need to be repaired? What kind of the repairing you need, or what specific kind of the what specific portions of your home that we need to repair? Can you give us the details? Here, you are not specifying them anything. You are ignoring their request, you are neglecting or you are refusing to point out the specific places that need to be repaired in your house. Okay. So when there is the negligence or refusal from your side, here, even if there is the non-performance of the contract, my team and me are not responsible for the non-performance of the contract which is caused by your negligence or refusal. Got it? So here you have neglected, you have refused to perform your part of the contract. You have denied that yes, I don't want to I don't know what part of my home need to be repaired, or I'm not going to point you out anything. I'm not going to cooperate with you. You denied it. You are not cooperating with the team. So how the person who is supposed to do the repairing work can know about your home? The person who is appointed to do the repairing work of your home, how that person is going to get an idea that what kind of the service you need, how the person is going to provide you the proper service of the repairing? Not possible, because you are not specifying anything to him. आप उनको कुछ सही ढंग से बता नहीं रहे हो कि घर का कौन सा पार्ट रिपेयरिंग करना है, क्या काम करना है, क्या नहीं. You are showing your complete negligence and ignorance to the another person. So here, such neglect or the refusal that is done by you, due to that, if the another party, that is my team, who has gone to done the performance of the contract, is not doing the performance and coming back, and here in these circumstances they will not be responsible for the non performance of the contract, because this non performance is not the negligence from my part. This negligence is due to the negligence from your part only. The person who is supposed to get the service, the person who is supposed to get the benefit, that person is itself or himself or herself neglecting or refusing to do the performance. Then in that circumstances, the non-performance is being done by that specific person only due to the negligence or refusal to cooperate from the another person, the another party, the front party, the opponent party is unable to do the performance. That is why the party is not liable for the non-performance of the contract, even if there is the contract of performance and even if the payment is done. Okay. So this is we have understood under section 67. Then comes section 68, which which starts about the chapter B, chapter 5. And chapter 5 speaks about of certain relations resembling those created by the contract. So uh, it speaks about certain kind of the relationships which has been created by a specific kind of the contract. Okay. So let's understand it step by step. The first part, the first section, section 68 of this uh, chapter speaks that claim for necessaries supplied to person incapable of contracting on his account. Okay. So what does it mean? If a person who is incapable of entering into a contract, or anyone whom he is legally bound to support, is supplied by another person with necessaries suited his condition in life, the person who has furnished such supplies is entitled to reimburse from the property of such incapable person. Okay. Here what this section is providing, any person who is incapable to enter into the contract, or anyone whom he is legally bound to support. Okay. For example, there is a person who is mentally ill, or who is not having his right mental state to enter into the contract. The person is lacking the mental stability to do the specific performance of the contract or to perform the contract in his behalf. Okay. And the person to whom he is bound to legally support. मान लो the person is having two sons or two daughters at his home and the person is having his wife at his home. उस वो जो इंसान है that person is mentally incapable to enter into the contract. वो खुद कॉन्ट्रैक्ट नहीं कर सकता because of his mental illness or he is dead. There are two situations. Either the person is suffering from the mental illness for which he is incapable to enter into the contract, or secondly, the person is dead itself. In these circumstances, the person is incapable or unavailable to enter into the contract. So, when the person is incapable to enter into the contract, but the person is legally bound to support certain specific person. For example, the person is having his wife and child. The person is legally bound to support his wife and child, obviously, because this is the responsibility of the husband to take care of the wife and children. है ना? But due to the mental illness or just because the person is dead, he is unable, incapable to do that. So in that circumstances, okay, there is a third party. There is the another person who is supporting the family, who is taking care of the family and fulfilling the conditions of their life, who is furnished such supplies to the family. For example, there is a outsider who is the not so close relative, but somehow that person is known to this family. He decided to help them out. Okay. So what he did? He took care of the education of the child, who took care of the wife of that specific person. He supported them to get a proper food, shelter, and he supported them in all possible ways. Okay. He gave a good education to the child. He gave the money for the treatment. He took care of the food and the income source of the family. Got it? So when there is the third party, it might be the close relative of the person, or it might be any person from outside or any outsider, whoever it is. If any person is doing such kind of the cooperation to the family, taking care of the family, in that circumstances, the person who is doing this kind of the activity is liable to get the reimbursement from the property of such incapable person. The incapable person, for example, this incapable person is having the property of the 5 lakh of the rupees. So the person who is providing them the food, shelter, education and everything, that person is liable to get the benefit or get the part from the property of that incapable person, because just because he is taking care of the family suo moto, it doesn't mean that he will do it always for free. The person is, if the person is the bankrupt or the person is having no property and this person is this third person is doing this out of love or out of emotions or out of without any expectation, that is a different thing. But if the person is the third party who is doing the cooperation or who is supporting the family, then in that circumstances, this person is liable or capable to get the reimbursement, the share in the property of the incapable person, because he has already done his expenses for the family members, for the child, for the wife, or for the incapable person itself. So he will get the right to get the share of the property or get the reimbursement of the from the property of such incapable person. Okay. Let's talk about the illustration of this section. A supplies B a lunatic with necessaries suitable to his conditions in life. A is entitled to reimburse from B's property. What does it mean? A supplies B a lunatic with necessaries suitable for his condition in life. Okay. B is a lunatic and A is supplying B all his suitable for his life, his food, his shelter, his uh, care, his benefit, his treatment, everything the person is taking care. Okay. So the person is capable to get the benefit or the reimbursement from the person of the lunatic person B. Okay. And to get paid, maybe it might be the whole amount he has expensed or the part amount he has expensed or whatever it is, he is going to get the reimbursement or the share on the base property for the recovery of his expenses for B or the lunatic person. Okay. The second illustration that I was just talking about few moments back. It supplies the wife and children of the bee a lunatic with necessaries suitable for their condition in life. Is entitled to reimburse from B's property. For example, the person B is died. Okay, B is not surviving anymore. So B is having his child, small child and wife, but they are incapable to take care by themselves. So there is the third person C who is taking care of the child and wife of the B. So here, when the person is taking care about the food, shelter, education of the child, who is taking care about the medical expenses of the wife, who is doing the expenses for the wife and children of the B, simultaneously that person is capable to recover his expenses from the property of that dead person B, because here the person who is doing the service, the person C, the third party, who is doing the service to B and his family, B's son, B's daughter, B's wife, that person is doing nothing for free. Obviously, he is doing all these things for exchange of something. Got it? So here the person is capable to be reimbursed to get the property in return, and that is why the person is capable to get the reimbursement from B's property. This is what we have discussed. This is what explained under section 68 of the Indian Contract Act. Then comes section 69. It speaks about the reimbursement of the person paying money due by another in payment of which he is interested. Okay. So what does it mean? A person who is interested in the payment of the money with another is bound by law to pay, and who therefore pays it is entitled to be reimbursed by the other. Okay. So let's read it again. A person who is interested in the payment of money which another is bound by law to pay, and who therefore pays it is entitled to reimbursed by the order. Okay. This section is very simple in nature. For example, uh, you have having a home. You are having a home, or you are having a house nearby. So you have rented me that home. Okay. आपने मुझे वो जो घर था ना, आप मुझे रेंट पे दे दिया. So I am paying you the monthly rent of the house. Okay. But after that, I got to know that you are having a huge loan on the house which you were supposed to pay, but you have not paid the loan of that home. And the amount of the loan is around 1 lakh of the rupees. Okay. So there is the due date of the notice is coming to me because as because I am staying at that property, the notice is coming to me that yes, the rent of the home is not paid. Then I saw the notice that yes, this home is in loan and the amount of 1 lakh rupees is still need to be paid. Then what I am supposed to do? If I am not paying it, then maybe I will get the another rent, but I have to leave this home. Then in that circumstances, I am paying that 1 lakh of the rupees on behalf of you, which you were bound to pay. Then in that circumstances, if I am paying that 1 lakh rupees for you, you are also bound to pay me that 1 lakh rupees to me. This is what told under section 69 of the Indian Contract Act. We'll explain it in a detailed manner in the next class. We can wrap the class over here, guys. This is all for today. Thank you. Closing the classes. Thank you. Bye bye.